How is everyone today? Just for a quick survey, how many people here work with firms? How many people work with government? Well, majority. And how many people are others, such as in-house education? Very good. So for those who work with firms, do you have a amount that you can get for pro bono that's creditable? How much do you get? 50 hours. Anyone got any firms give different amounts? I know my firm gives up to 150 creditable, but then it's a whole end-on accounting about how much that can count towards billable and how much it can. So different firms have different things. So the title of today's presentation is Pro Bono. It's a good thing. And the purpose of my talk today is to try and convince you that not only is pro bono a good thing for people who need help, but it's also a good thing for the places you work. It's a good thing for the courts in which you practice, and it's a really good thing for you. So I hope by the end of the presentation, you will be convinced to do pro bono. I wouldn't be fitting with the theme of the conference, however, if I didn't also give you some tips for advocating on behalf of your pro bono client. The punchline for advocacy for pro bono is that you'll do fine as long as you take it as seriously as you take your advocacy for paying clients. The reason is, one, it's a good thing to do. It's the right thing to treat your clients well, whether they're paying you or not. The second reason is, and this is something that as a young attorney you might not have experienced yet, it's going to be your name on the brief. You're going to be your signature saying, I submitted this, respectfully submitted, and everything else. And it's going to be you behind a podium like this, facing a judge. And if you haven't put in the time, the same time for the pro bono client that you put in for your paying clients, it's going to be a very awkward 15 minutes. It will be, in fact, a horrible 15 minutes that you will remember for the rest of your life. So you want to be prepared for being in front of that podium. At the very least, you want to avoid finding yourself being berated by a judge in an opinion. They won't do this as long as you do a good job, as long as you are advocating well on behalf of your client and you put it in. You might lose, but the judge will be nice to you because they want people to do pro bono. But if you don't do it, you might end up like the poor attorney who's featured in today's ABA journal that got emailed me this morning. He wasn't so much doing pro bono, he was doing pro se, but the judge has written up a nasty decision about what a horrible man he is. This is a guy who's graduated from Columbia, so smart guy, but now he has a published decision saying, you are a bad guy and you owe me $10,000. Avoid that. So that's the thing that sometimes becomes a career-limiting move for people when they do pro bono work, is that they skimp on the time. So that's the punchline. It's a good thing to do, and treat a pro bono client the same as you treat any other client. So as Laura mentioned, during my usual life, I do government contracts, which involves a lot of deep diving into the federal acquisition regulations, and every agency's got its own acquisition regulations, along with antitrust and white collar. In my pro bono work, I do immigration and criminal defendants. And the reason we do this is because they need help, and it really enhances your skills as an attorney. Now, your law firms, the ones that offer up to 50 hours and some offer other ones, they are encouraging you to do this. Why do you think law firms encourage you to do pro bono work? Anybody?
Public relations.
Public relations, yes.
That makes them look good.
Makes them look good. They get written up. They get, the partners get invited to nice parties thrown by the right people, saying, aren't these all great guys? So there are some self-interested motivations, none of them bad. Are there any other reasons a firm might be encouraging you? Yes?
Good practice for the associate.
Exactly. And so that's where the firm's incentives are coming in. Now, the courts like to encourage you to do pro bono, and they'll set up programs. Why would they do that? Why do the courts do that? Right. Judges have a ton of sympathy for claims in front of them. You don't become a judge if you're an unsympathetic person, if you lack any empathy whatsoever. And it's very frustrating for judges to have people consistently in front of them who they can kind of sense have a claim, but they just can't articulate it, and then they get railroaded and pushed out of the system. So, lots of people can't afford pro bono representation, and there are about 2 or 3 areas where you're primarily going to find opportunities to do pro bono. What are some of those areas? Domestic, yes, that's a huge area. people need help. Really, you can't help out every situation. There's obviously always a lot of personal stuff going on. But you can at least explain people's options to them. They can understand the situation, they can understand what their options are, and that can be enormously beneficial for sort of cooling down the temperature between the interpersonal relations. Even if you can't rescue whatever is going on, at least you can help have it progress in a good way. Any other places? Landlord tenant, yes. It's a extremely complicated area of the law. Has anyone done any landlord tenant law in Virginia? You have? Oh. Yeah?
Yeah.
On a pro bono basis? Or
No.
No. But yes, there are always tenants who feel they're being improperly evicted, and obviously it's a good thing to do to help them keep in. And, as written by the gentleman over there, can actually lead to paying work. It will give you experience. What other areas? Immigration, yes. Yes. Immigration, yes. Immigration is the primary area that I do pro bono work in. And the reason that I chose to do it was, one, my firm had an established program set up with Catholic Charities to help out. But B, there's just an enormous need. There are a lot of immigrants in the country with varying levels of documentation, and the immigration law is hard. Like, I do government contracts, and I've got the Federal Acquisition Regulation, which is about 1,000 pages thick, single spaced, and then every agency has an individual supplement. And then there are all these laws. That's easy compared to immigration law. Like, even the forms in immigration law are written in such a way where you have to think them through. And especially if your first language is not English, it's easy to run afoul. And then all of a sudden it's like, oh, you lied on a form, all of a sudden we're not letting you stay in the country, and your life's been turned upside down. So that's why it's extremely valuable to have lawyers in the immigration context, not only litigating in front of either the Board of Immigration Appeals, or even taking appeals up to the Fourth Circuit, but also just in going to the weekly sessions they have on Saturdays, and just helping people who are applying to adjust their status or do other things, just make sure they hit those questions correct. Because hitting the wrong box and then having the ALJ realize that you didn't understand something, maybe the ALJ takes a side, but maybe he doesn't, maybe he causes you up. So that's why it's really important with immigration. Has anyone ever practiced in Virginia General District Courts? You in the green, what have you done in the General District Courts?
Just civil litigation.
Okay, small claims and stuff like that?
Yeah.
Which district courts?
Fairfax, Arlington, Mason.
And are they the same, the practices, or are they different? Yeah, they're different. That's why, like, anyone else do the General District Court law? Yes? Or what? Okay, any other parts other than Fairfax? Okay. How have you found the experience? That's a really good description of it. It's tough. Like, I did my first pro bono case was actually a little bit unofficial, which is something I'm going to tell you later to avoid. But the lead partner in my group walked into his office, started stretching out his leg on my desk because he had pulled a hamstring, and he said, "Chris, I've got a girl who lives in my basement." I was like, "Okay, that's weird, but let's proceed. Where is this going?" And it turned out she had managed to get herself a DUI, a reckless driving on a suspended license, and like 2 other violations with a single traffic stop. And she was young. She was 20. She made the DUI worse, but luckily the cop hadn't picked up on that when he had entered information in. But it was a big deal. She was an immigrant, so this could have potentially getting kicked out of the country implications. And in Virginia, there can be generally going to jail implications fairly rapidly with DUIs. So I had to go and figure out what to do in Alexandria General District Court. So I called them up, it's like, well, I've got a motion to file. Do you have a form book? They're like, no, they don't have a form. You call, basically, if you want to make a motion in General District Court, you get up and you say, I've got a motion. Now in Fairfax, they actually do have specific colors that you have to put on your binder, because the partner later came into my office and gave me another pro bono client who got a reckless driving charge. So every General District Court is different, and it's bewildering. If you're just a person who is going about your daily life and then you get pulled over, and you're like, oh yeah, the cop caught me for speeding, Cop doesn't seem to care, cop seems to chill with it, I go on my way, and you look at the ticket, it says reckless driving, that's a big deal. That can get your license suspended, that can mess up your ability to get to work if it's sufficiently above the speed limit. If you're into like the above 83 miles per hour, you can be looking at doing actual jail time, and people really don't like that. And so it's bewildering, and people have a tendency to put it off. So what you can do as a lawyer, even if you've never appeared in general district court, even if you've never done any of this, is at least say, yes, this is important, and these are the steps we're going to take. If you can break it down for them, it's a lot easier for people who have other jobs and other things in their life to sort of process how they're going to be able to get through this, and that can be enormously beneficial. Beyond, and then obviously there are more serious cases. You get charged with a felony, you get in, obviously in Virginia, you are arraigned in general district court, and then you get bounced up to the circuit court. And once again, that's overwhelming for people. They have no idea what's going on because they have other things to do with their lives. And so you being there to sort of say, this is what we can do, and really carries a lot of pain. Now, on the employment side, it used to be that every place you play said, have you ever been arrested? Have you ever been convicted? And you check the box, and if you had, that was real complicated employment. Now, more and more jurisdictions are banning bonds so that they can't ask that bonds. However, it can still make an enormous difference, and this is why it's really important to get to a lot of people, especially the low-level criminal kind of stuff, is that the type of conviction makes a big difference. There's an enormous difference between being sentenced to 364 days all suspended versus being sentenced to 365 days all suspended. There's an enormous difference between being convicted of speeding going 83 in a 55 zone versus being convicted of reckless driving going 83 in a 55 zone. There's an enormous difference between getting convicted of, say, disturbing the peace, or public intoxication, versus, say, assault and battery, versus, one kind of line, kidnapping. Kidnapping is a really bad thing to have on your record. So even if you end up sitting in jail for the exact same amount of time for the intoxication or the kidnapping, it's enormously beneficial if the lawyer there can say, let's work this out. Let's not have him, plead kidnapping. The odd thing about the criminal justice system is that if you're a hardened criminal, it's not that intimidating. You've been through it before, you know everything, whatever. But it's the innocent people who can really get railroaded by the criminal justice system, and that's where being an attorney on a pro bono basis can just be enormously beneficial. You can save someone's house, you can save their marriage, you can save their job. It can just really make a huge difference in how their life turns out. And another thing to remember about the pro se litigants is that, by and large, they are smart, they are hardworking, and so never underestimate them. And they may, but it's really important that you convince them that they should not try and undertake this on their own, not because we're trying to protect the legal profession as a guild, but because there's a lot of horrible advice out there on the internet. So everyone here knows what FOIA is, right? Everyone here knows what the Big Feet Act is, right? How many people here have heard of the Act of Congress of February 21st, 1871? There is a religion on the internet devoted to the idea that when Congress passed the law of the Act of February 21st, 1871, don't Google it, you might start getting tracked. It essentially disbanded the US government, made all laws passed by Congress only applicable to the District of Columbia, and therefore, if you get a federal arrest, you don't have to obey any federal official outside of Washington, D.C. Hopefully you'll never run into these people. I ran into one of them when I was at the DOJ, and he wasn't happy that he had been arrested for not only failing to file his taxes, but making money by selling kits saying, you don't have to pay your taxes either. And he was all about that he didn't have to go to jail and no one had jurisdiction over him because of this Act of February 21st, 1871. I actually looked it up. It was basically Congress's first attempt to organize a government in the District of Columbia. It says nothing of what they said, but that's just the type of just horrible advice that's out there. So even if your client is diligent, it's easy for him, if he's off on his own, his or her own, just to totally get sidetracked and make arguments that are going to perhaps provoke a very hostile reaction from the judge. The judge probably has heard this before, has been warned about it before, and he doesn't know if he's dealing with just a guy who's gotten a little lost on the internet, or if he's dealing with one of the people who literally thinks he has the right to run up and push aside the marshals if they try to arrest him because he's a sovereign citizen. So that's why it's really important that you try and convince pro bono clients that they don't want to take this pro se, that it is important to follow the process. As I mentioned earlier, another reason that's really a good thing to do is that many of these people in the more civil context, and in the criminal context, they actually have a very legitimate claim. You don't hear me if I'm talking over here versus over there. Great. This was an experience I had at the DOJ. I was in the National Court section, so we represent the United States in the United States Court of Federal Claims and a bunch of other courts. This guy filed a claim against the United States. He said that we had taken $50 million from him. We had defrauded him. It was written on paper. It was, it looked like a chicken had written it. It was utterly incomprehensible what he was claiming. But you go back and you look at the case history, and this guy had cases all the way back to Louisiana, going back a number of years. And you felt bad for the guy. Someone had defrauded him of his house. It was, at least according to what he alleged in his original complaint, they had gone through a series of transactions. He was undereducated. He didn't understand what was going on. And somehow at the end of the day, he had paid them a bunch of money and they ended up with his house. So he has a claim. A wrong had been committed to him. So he tries to do it himself. And he files suit in federal court. The problem is, he's from Louisiana. The guys who stole his stuff are from Louisiana. He tries saying they violated all these sections of Title 18. Title 18 is the criminal code, so clearly he can't bring a claim. The district judge dismisses his case because there's no diversity, there's no federal question, and he can't bring claims under the criminal statutes. The district judge puts in bold, all caps letters, you sound like you have a claim against these guys. You should file it in Louisiana State Court. You should file it in the parish where you're located at. So he refiles his case in federal court, this time suing the federal judge for dismissing his case. And so he goes through this process, and he gets kicked out of Louisiana, and he gets up to the Fifth Circuit, and then he tries to go to the Supreme Court. Somehow he gets a piece of paper that he thinks means that the government defaulted, so he is owed this money. And so he finally ends up on my desk. He still doesn't have a house. He's still out this money. And obviously I have to get him dismissed, but it was just heartbreaking. Because this guy clearly had a wrong committed against him, but because he didn't have a lawyer at any step of the way to say, stop, no, you just need to bring it under Virginia law, under Louisiana law, saying fraud or conversion, he had lost the house. And so judges see that all the time. They see it, guys who might have a defense to a criminal charge, whether it's entrapment or anything else, and they lose it because they don't have a lawyer. And so that's why it's extremely important to go out there and be there for other people. And the other thing to recognize is that experiences like the guy in Louisiana, that taints the whole view of the judicial system. People aren't going to understand because they know useful things like how to build houses or how to build cars. So they're not going to understand, oh, they didn't have diversity jurisdiction, there's no federal question. All they understand is this guy lost his house, and now he's totally out of a job, and the courts didn't help him. So when you help pro bono clients, you really help the system as a whole. Let's focus on you. Pro bono is a good thing for you. Back in the day, my dad was a lawyer too, and back when he joined the firm, the same firm he was with for 40 years, their goal was to train excellent special generalists. And so they bring them in, and probably their third year, they're like, hey, client's got a little $50,000 case. Why don't you go down to the county courthouse and see what happens? So they try and do it, and their trial, their error, and eventually by the time they came off for partner, they actually had a variety of experiences dealing with all their cases. The firm model has changed. The firm model now seems to be, you want to have the best specialists in the world. So we're going to have the best municipal bond plaintiff side attorneys that there are. We're going to, Chris is going to be the expert on making sure you comply with the FOSI requirements of the NISPOM. I say that, and I'm guessing no one has any idea what I just said, because you're used to times. So, you don't automatically get the sort of experience of knowing this is how the judicial system works, this is the experience I'm getting. Now, that can be fine if I get to become a partner who does FOSI and NISPOM. But it's not fine if I want to do something else, if I decide I don't really like FOSI and NISPOM. Or if I'm coming after a partner, they're like, well, does he have any experience other than just running NISPOM to the ground? Does he have any experience doing depositions or pleadings or arguments? And the answer is no. There are going to be a lot of partners in the group who are like, maybe not. So that's what pro bono really does for you. The firms will make sure that will put you before a trial judge, before an appellate panel, a lot sooner if you're doing pro bono work than they will for a paying client's work, because the client's paying for the partners. You also might say, well, Chris, I really want to be a municipal bond default plaintiff side attorney. Why would I have to need to know immigration or criminal law? You would be surprised. A lot of investors here are, and a lot of highly paid workers are here on various forms of visas. There's actually a specific form of a visa for investors if they're willing to put up a certain amount of money to invest in a certain program. Thus, it is enormously useful to be able to say, yes, I understand the form you just received from the ICE. This is what we need to do to comply. Or, okay, you got into a little bit of a spat that now you're in general district court. You want to try and bargain yourself down to something non-violent in under 365 days, and you don't want to bargain yourself to something that's going to be 365 days and that's with all the way to trial. That's enormously beneficial to them. It's also enormously beneficial because like, a lot of people who tend to run clients, they have just adorable just adorable kids. And they tend to have encounters with police. They tend to have an interesting and nuanced view of how the requirements of the world apply to them. And so if you can be the person who says, yes, I know how to go down to court in Arlington versus going down to General District Court in Alexandria, which is very different than General District Court in Fairfax. And I'm not going to get lost. I'm going to know which judge, and I know how to interact with the Commonwealth attorneys down there. Now, you'll become very close to that client, and that's a really good thing. And so there is a lot to be said for having experience broader than just a specialized niche that you may find yourself being funneled into. Also, the thing that really sells you, that every lawyer kind of knows is a good thing to have, is first chair experience at a trial or at an oral argument at the appellate level. People understand that at a visceral level. And so when you're up at the partner, it's like, yeah, he did this. He actually handled the motion himself. He handled the trial himself. People are like, okay, yeah, he's a real lawyer. Like, he can walk and chew gum at the same time. This is the type of guy we want. It'll also help you in your substantive work because of the point I was talking about earlier about when it's your case, it's your name that's been signed at the bottom of the brief. It's you behind this podium facing off against Judge Easterbrook, who may or may not be in a good mood that day. And so that will change and make it a lot better in how you write your briefs. You will add your memos. When you're writing a memo, it's kind of nebulous in your first year. You're like, well, this case law in law school, we were told to say there is no real answer. So here we go. Once you actually have had to put a brief together, you're going to be like, okay, I need this. And the person writing the brief needs to know this and has to have this quote, and he needs to know these two C's and why they're distinguishable. You'll be able to write a lot better. You'll be able to research a lot faster. You'll be able to breeze through doc review a lot faster because you'll know what actually is going to end up in the black and white of the brief. And there's no other way to get that than actually being the person who has to put the final brief together, who actually has to click submit up to the pacer. There's no other way to get that. It will also give you a good perspective on the stress levels of partners and senior associates. As younger attorneys right now, it might seem that they're kind of jerks. It might seem that, why do they have the things they have? Why do they have their peccadillos? And once you've actually dealt with something where you're sitting there, and over here is a guy who's saying, that guy's brief sucks for this reason and this reason and this reason. You'll be like, oh, I understand why the partners are really, really tense about stuff. I understand why they really care about what the cases are on the side. Whether I triple cite, check the citations to the records and everything like that. Will give you an enormously beneficial perspective that will allow you to help them. And if you help them, they'll help you. It'll also be, if you're going to stay with the firm for the rest of your life, perhaps it'll give you opportunities to work on cases where the client is more sympathetic than they might otherwise be. I'm sure we all represent angels and nuns, but sometimes it's nice to have to be honest, represent good guys. So, not that our clients aren't all good guys. So, how do we get pro bono work? So, before there was a show of hands that indicated some people worked at a firm. Can I see that show of hands again? So, how is pro bono set up at your firm? I know you said that you had 50 hours. Is there a committee or something?
There is one partner in the main office that is coordinating with Catholic charities.
Okay, very good. Does it work any different at any of the other firms? coordinator, who's one of the lead partners. Then she has a bunch of organizations, and then there are different partners who are sort of lead partner for each of the different charities we partner with. And that's easy. If you want pro bono work, you go to them, they set it up. If you're at a firm that doesn't have that, then you need to sort of approach the partners and discuss it. If you, and you've got to say, okay, and just don't go up to partners and say, hey, pro bono work, yes? Come up to them and say, I would like to do this type of pro bono work. Here's a list of organizations that sort of assist firms doing that pro bono work. What do you think of that? They're much more likely to get a positive reaction to that, and assuming they approve it, that's definitely something, you'll get credit for being a go-getter, for showing some initiative, and you'll also get credit for knowing sort of the lay of the land of the firm. Now, a word about that. You have to get a feel for the partners in your firm. When you're in law school, sort of everyone says, pro bono, it's the best thing in the world. Pro bono, you should definitely do it. Everyone loves pro bono. Firms love their invitations to the receptions. They love the credit. They love your experience. Go get it. When I was interviewing for firm jobs, I was interviewing with a very prominent place, with a very prominent attorney. And he said, well, what do you think of pro bono work? And I give him a pretty canned answer. Probably your law school, I think it's important to represent la-di-da-di-da. And he said, I hate pro bono work. It devalues the work of all attorneys in this area because we give away so much work for free. So there are, contrary to what this is during an interview. They hadn't even hired you yet. So contrary to what you might have learned in law school, there are partners who don't want you to do pro bono work. And so definitely don't sort of freelance pro bono work. Make sure that it's okay with the firm, and sort of get a feel for which partners at the firm might be more receptive and more willing to sort of sell it to the firm as a whole before you go into that approach. So it's a mistake to assume everyone's going to be enthused about pro bono work, because there are definitely, as I discovered, partners who are not. So is there people who are here who are in-house or with educational institutions or publications? Do you guys have pro bono work? How does yours work?
Well, our company is set up, it's global, so we have like a Palo Alto coordinator, that was turned in, we have a Bernie coordinator, and we partner with private charities and other global organizations as well, so that's not very good.
What do you do when you do for the Catholic charities?
I was actually supposed to today, I guess, it's the ALS in it.
Okay, yeah.
Yeah, so it's like two separate people, there's the other kind of stuff we do.
Okay, cool. What about you?
I guess you could say I'm a pro bono client because I'm in-house at a nonprofit.
Okay. What's the nonprofit?
It's also a climate reality project.
Okay.
Outdoors.
Oh, very cool. Anyone else? Yes.
I work for a nonprofit organization. We have pro bono attorneys. Actually, one of our pro bono attorneys here. So we reach out to different law firms, and they came to our office 1 day a week for 8 hours.
Oh, wow.
Yeah, so we do mediation.
Okay, fantastic. So as you see, some places where you're in-house, they actually have a process by which they actually allow you to get pro bono work by going and helping people with the intake process and stuff like that. And then also, we've done a good perspective on how firms get approached for pro bono work and how other places can get approached for pro bono work or approach others for pro bono work. We contact the coordinator for the different charities, and they'll be more than happy to set you up. They always need more help. It's a little trickier with the in-house and some of the other propositions to do sort of the trial level work. At least in my experience, when I've talked to my friends who are in-house, there's, Amazon, GE, Ford, their business is not providing third-party representation to people in court, and they're much more cautious as a whole about allowing to go into court. As I discussed earlier, however, having people who can help people through forms is just enormously helpful, because like a mistake on a form, I've been dealing with a guy who made a mistake on a form that's been haunting me for 14 years. You try and get it overturned, but like, oh, you signed a penalty for perjury. It's just enormously helpful. So if you're in-house, please keep doing it. And so, and there are people here who do government as well, right? Like, you guys do government, right? You guys do any pro bono?
It's funny, I tried to
asked the question about like, oh, how, what are the rules on this? And after a 3-month searching process, somebody kind of found what the policies were. And from what I gleaned from it, it basically seemed like as long as you're not going against the federal government, as long as you're not going against the federal government, you can pretty much do whatever you want. That was kind of the conclusion I came to after a very, brief investigation that led to nothing. So, yeah. But the organization actually had no set, like it wasn't like, oh, we work with Catholic charities or that. So, okay. Do that?
Yeah, I found it depends. I mean, I work now for the executive branch, but when I was working for the judicial branch, it was any case that may come before our federal court, that's a no-no.
Okay.
But you want to do something at the state level, at a very low level, probably that's okay.
Right. When I was with the Department of Justice, pretty much it was a blanket no. And the rationale was, look, we pay you to represent us, and we don't want to find you going up against one of our attorneys. And yeah, state, maybe you don't, but what if the guy decides he needs a habeas petition? All of a sudden you're bouncing up and it's DOJ versus DOJ, and that looks bad. So your different agencies will have different rules. The rule I was given at DOJ was, unless it's your grandmother closing on the house, no. So, but I'm delighted to hear that there's actually a lot more flexibility. So you can pursue that even if you're engulfed in your own house. So now we're going to come to doing pro bono advocacy. How many people have done trials? How many people have done motion hearings? Were you first chair?
Yes.
Cool. What was the motion vote?
It was just a motion for
Okay, well, that's cool. Anyone's ever done an appellate appeal? Yeah, I mean, it's going to be rare, and so this is sort of my, my chance to give you the first impression of what sort of I do is when I'm doing advocacy, and it's not that different from what I do for paying clients. The judge will appreciate your work. The judge will know that you're working pro bono because when you finally notice his appearance, like, are you paid, are you government, or are you doing it pro bono? So you check that box. So they'll appreciate that, but they're still going to expect you to hit the wickets in terms of being on time and hitting the page limits and font size and everything else. So it's important that you be on top of what are the requirements, because different courts just have varying requirements. When I was with the DOJ, we practiced in front of the federal circuits. The federal circuit handles patent appeals. Pretty complex stuff. The federal circuit was the last circuit to adopt electronic filing. So despite handling the most technologically complex stuff in the country, you still had to know when are the deadlines, when is the absolute last time I can give something to the copier and be sure that they'll be able to hustle it on over and get it into the 9th Dropbox. I had to know absolutely that it was 12 point, they preferred 14 point, but that was ridiculous, so no one did it. So it was 12 point proportional spacing, serif font. You had to know all those little rules because they would throw your brief back at you if you got it wrong. So this is the frightening thing when you're a young attorney. People are going to start taking you seriously. They take you really seriously. They'll expect you to be the expert on the procedure and the substance. And so you're just going to have to know it really well. So it's not hard. Just read the rules and you read them a couple times and it'll be boring. But then you'll know it and you will know probably more than most of the partners in your office about what the actual rules are. You become the go-to person. For writing your brief, you obviously can all attend Brian Gardner classes. But the important thing is to make sure that the arguments are on point and that they're short. You want to make sure your argument headings tell the judge exactly where he's going and exactly why he needs to rule for your client. The one tip I will give you is that when you're doing a response brief to a motion or a reply brief in support of your motion, don't start off your argument sections with a description of what the other guy said. Because the temptation is like, the other guy just said that we should lose because blank, blank, and blank. And then you write your second sentence. He's wrong because blah, blah, blah. The problem is that you started off by telling the judge what the other guy said. You might think, yeah, that was a good point. You guys should lose. So you start off with your own. So if writing a response to a motion to dismiss, like any complaint, we established that we should pause, that it was that guy, and that he harmed our client. He now is trying to nitpick about this, but he's wrong. And if you're doing the reply brief, you just go back to your motion. In the motion, we show that it should be dismissed dismissed for this, this, and this reason. In the response brief, he gets it all wrong, and this is why you should grant a motion anyway. So that's the one tip. Oral argument. Oral argument can be important. It's certainly important for your professional career, because the partner is going to want to see how you do. Your client and the agency that referred the pro bono matter is going to want to see how you do. They don't want to be referring the people who come to them to help, the people who don't know how to do an oral argument. So when I do an oral argument, I prepare something like this. I staple multiple manila folders together, and that allows me to flip through fairly easily. And it is not as distracting for the judge as if I had a legal pad and was doing that. It's looking like that. And the other nice thing is that you can rate your case citations over here on your blank pages. I don't have any blank parts of this because it's just a presentation. But you can write down sort of your short summaries, and it's right there. So that you've got 2 pages. And the judge asks you, what about this case? You're like, oh, that case. Well, that case isn't effective because of this reason. And you can go straight along. A lot of the times, temptation is to bring in a flood of paper into the courtroom. So you'll have your cases, and you'll have all your statutes, and you'll have all your regulations, and you walk in like a traveling encyclopedia salesman, and you're trying to set yourself up. If you're at an oral argument, and you're like, oh, Your Honor, let me go and look in the notes to 5 U.S.C. 705, it's not a good thing. That's a bad thing, because the judge is going to get impatient as you're sitting there thumbing through things. And it's really kind of dangerous if the judge asks you, well, what about this case? And you have to go back and look at it. Now, if you got it, you got it. But it's kind of dangerous to say, well, I think it's in this case, right about here. Because it could be that you're picking that sentence out of context, and that there's maybe it's a description of the argument that lost, and it can be destroyed. So it's really important to prepare for arguments, know what your best cases are, have them written down alongside on this little folder thing, so that you can respond very quickly and you know where to go. It's sometimes better to say to the judge, I'm not really ready for that, but I can give you a brief later if you want. Once again, that's not a good thing. It's not the worst thing. The judge wants an answer now, but it is sort of a better fallback than trying to dive into the blizzard of paper you brought in with you and trying to find the answer there. I once was doing an oral argument in the Eastern District of Virginia for a pro bono matter, and I said, okay, well, I just wanted copies of the statutes. The person who printed them out interpreted that command as the cases and all the citing notes. And of course, I had cited 28 U.S.C. 1331. There's a lot of accompanying notes to 28 U.S.C. 1331. There's a lot of accompanying notes to 5 U.S.C. 702, the APA. And so as a result, it was unworkable. And I just sort of had to go in basically only with this, because I couldn't be assured that I could find what I needed to find. You can invite your clients. Honestly, don't be surprised if they don't show up. The referring agency will probably send someone, the law firm will probably send someone, the client's got better things to do, and unless it's like the hearing, unless it's like the actual trial, if it's a motion to dismiss, they might say, look, I'm not going to understand, I'm not going to show up. So don't be insulted about that. What is the most important thing to do at oral argument? Anyone? I guess. Listen, yes. Listen is by far the most important thing to do. Is if you're listening to the judge and say, where is he really trying to take me with this? Where is he trying to take my opponent? Is he just trying to say, no, I think you're wrong, you've got to abandon that argument and find something new? Is your opponent conceding something? Is your opponent saying something he shouldn't? That's really important. So, if the firm will let you, you can always bring someone else along who can take notes so you can spend more time listening and writing down short notes to yourself. But it's really important just to be able to listen. Also, it's very important to make sure, and this goes to the brief writing process as well, that you are not doing straw man. What's a straw man? A straw man is when you mischaracterize the other side's argument to make it easier to defeat. And that's easy to do unintentionally, but it looks intentional when it's in front of the judge. And the reason it's easy to do is you read the opponent's brief once, he says not nice things about you. You don't really want to read it again because it says all these mean, nasty things. And then the arguments sort of morph in your head, like, oh, I can knock out that one here, that one's easy, here, here, here. Always, when you're drafting your brief, always be reading the other side's brief. Before you begin, read his or her relevant sections every time you draft your relevant responses, and read it at the end to make sure that you've actually answered everything he said. It's so easy to get sidelined by a mischaracterization of his argument that's not really there. The best oral argument I ever saw was from a very small man. He wasn't very smooth. He was not a very good speaker. He wasn't with a big firm. He wasn't particularly impressive. But he walked into the Seventh Circuit when I was working as a judge, and as a clerk. And he managed to change the minds of 3 appellate judges in the course of 15 minutes. It was an amazing feat. Like, this guy was very quiet, very shy, and they were just hammering him, but he knew his stuff. He knew his case law. He had so much experience that he was able to say, yes, Your Honor, in fact, you can repossess a lease if it's below market value as part of the bankruptcy proceeding. He knew his stuff so well that he changed the minds of 3 appellate judges. It's really hard to change the mind of 1 judge. So the fact that he was able to walk in there and do it with 3 is just amazing. Other points, sort of more shallow about your oral argument. When you go to the oral argument, you want to be dressed nicely. And what does nicely mean? Well, it depends on you. Fairly conservative dress is to be advised. Probably this tie is a little weird for an oral argument. It's purple. I chose it. But I would go with a more stage tie if you're a man. Any of the outfits here being worn by the women would be fine. The one thing you don't want to do is make the judge think about your outfit. I have seen a man walk into an oral argument wearing a polo tie and a seersucker suit. My first thought was not about whether his arguments went good. My first thought was, he looks like Colonel Sanders. It's really hard to get off the thought of, I listened to Colonel Sanders talk about this case. I've seen a man walk into an oral argument from the Seventh Circuit. He had jet black hair pulled back in a ponytail all the way to the middle of his neck, the middle of his back, and he was wearing a blood red shirt. It looked, once again, I'm not thinking about what he's saying on behalf of his client. I'm thinking about the fact that he looks like a goof. And the final example was, it was an associate taking a pro bono matter. Great for him, he's in front of the Seventh Circuit. Great that he's in front of the Seventh Circuit, getting an argument in front of the panel judge. And his suit was probably 9 sizes too small. And the reason it was really weird was that this guy was a rail to begin with. He was a lot skinnier than I am, but like his button looked like he was about to pop off and shoot into the judge's eye. So, it is something that fits. So don't make your clothes the topic of the judge's conversation. Make sure that they look good, make sure that you're prepared, and that you're ready to answer. After you've done your post-argument, done your post-trial, if you've gotten a decision, such as in a trial, you obviously know exactly what to discuss with the client. If it's an appellate case or motion to dismiss, discuss how it went, see if they have any suggestions, see if they want any follow-up, any Rule 28J letters, see how it does. Confer with the partner, confer with the referring organization to make sure that they approve of how you did, if they have any suggestions. Going back to a brief thing that I missed with the briefs. With the briefs, especially if you're a firm that's doing work through a pro bono referring agency, it's very important to budget in time for review. Because you not only have to get the partner to sign off on it, but you also have to get the agency to sign off. We work with Catholic Charities, and Catholic Charities has very definite opinions on what are good things to say about where the law should progress and where are bad things. And so you don't want to put the partner in the position of having a half day to totally rewrite a brief because Catholic Charities is saying, we would rather default in this case than have you file this. They've never said that, I'm sure they wouldn't, but they have very definite opinions, and you need to budget that in. So you should give at least 2 days for review for each person who needs to review. So generally that means 4 days of review. You're going to have the referring agency review it, and you're going to have the partner review it. So work backwards. Say, when's the brief due? Okay, 4 days from that is going to mean I need to have it finalized for review, and it's going to take me this long, and you can work back. And your 40 days, you get to file an appellate brief, disappears really fast. It's amazing how fast 40 days go. It's amazing how fast 30 days go. And for a reply brief, you can get 14 or 10 days, depending on the court. It seems like no time. It seems like you pretty much have to write it the day you get the response brief. So just remember, timing is really important. What does this all lead to? If you do this successfully, it demonstrates to the firm, I can write briefs from beginning to end. So no, they're not going to the next day give you say, hey, write an appellate brief on behalf of the big company that's about to go bankrupt. But they'll say, hey, maybe you can do some discovery motions. Maybe she can, do the motions and eliminate this case. And that's the way you start getting really substantive legal writing experience. You can show that you're good at selecting arguments, which is really important for partners. Partners, the valuable thing they have is time. And so if they know that when you walk into your office, you're going to bring them the best and you're not going to give them a lot of irrelevant detail, they will love you. They will come back to you. They will never stop calling you. It will be annoying. But you will have work and you will have a future at that firm. You are a master of the filing requirements. This is very important. Partners are very busy people. They have a lot of client relationships to watch. They tend to forget, okay, when does this need to be in? What are the service process rules? What's the font size? All that stuff that doesn't sound important until all of a sudden you have to explain to the client, yeah, we have to run another 14 copies of the brief because it got rejected. That stinks because the client thinks you're a fool and doesn't want to get it going. So give yourself enough time to do it. And here's some tips of what to avoid. Do the work. Put in the effort. I once saw a guy in front of the 7th Circuit again, and he got up and was like, Your Honors, it's so great to be here. I've got my client, Farmer Joe, who was a farmer. You know, he's back here with his wife. They've come all up here to see the big day. And this is a case just about the horrible injustice that was done to them. And my judge's first question to him was, Counselor, why under the clear precedents established in this circuit in the following 7 cases do we have jurisdiction? It turned out that he had missed the entirety of the reason why his in-state client did not have jurisdiction over the in-state defendant. They had litigated the entire case. He looked bad. That's embarrassing. And so I could give you a lot of other tips about how not to look bad, but they all boil down to one thing: prepare. Know the cases you're going to cite. Know the cases the opponent's going to cite. Know the record backward and forward. The record next to your outline is the most important thing to bring in with you to the argument. If it's too voluminous, you can always bring in the important excerpts. But just prepare. Prepare, and that's the really important thing. The other important thing is for those of you with firms, don't do what I did with Andre, the referring partner for my DUI client and the reference driving client, and something to others over the years, don't freelance, because everyone here knows what a client conflict is. So the danger is that if you freelance and just sort of doing great stuff without having the firm's blessing, you'll create a conflict. And then all of a sudden, paying client will be like, I'm walking out the door because you're representing that guy in the landlord-tenant dispute, but he's the same guy who's been banging on my door for the last 6 years, claiming that he owns the Northwest Territory and I need to get off his land. And then they're going to be like, they're going to come into your office and they're like, we encourage you to explore other career opportunities. And we encourage you to do so in the next 2 weeks. So definitely make sure that everything you do is done through the approved channels, because stepping outside them can have some really bad and very rapid consequences. So, are there any questions? Yes?
When you help immigration clients, is it helpful for you to know another language? Do you know another language?
I do know German and Russian, not a language that comes up a lot. Generally, Catholic Charities is really good about having the interpreters. And with the cases we've had, in both cases, they were long-time people who lived in the United States for a really long time. So they actually had family who were very fluent. And they knew some of this as well, but it was more their family who was able to provide us continuous interpretation. But it is really helpful. I wish I did know Spanish. Vietnamese, obviously, in the Northern Virginia area would be a very good way. Useful language to know Korean, very useful language to know, and increasingly Mandarin. Obviously, these are kind of hard things to pick up. CLEs are their time. But if I was doing it more, those are the things that I wish I had. Any other questions? Okay. Well, I'm going to present a scenario. And this scenario we actually confronted with one of our clients. And the outcome of the case is happy. He's still in the country. He gets to stay here permanently, so we're all thrilled. But I want to see what sort of arguments you think we should have made. So, the situation, and it's also an example of why it's always necessary to give representation. The situation is that he's an immigrant. He's in the country starting in the early 90s. He's here illegally. He commits he does something which involves someone being pushed into a car. He gets charged with kidnapping. He gets pled down to simple assault. He gets sentenced to 365 days, all suspended sentence. This is in 1995. In 1997, I think Congress passes the Illegal Immigration and Immigrant Responsibility Reform Act, called ERA. That changes the definition of what's a serious violent felony from something that gets you sentenced to 5 years to something that gets you sentenced to 1 year. So you've got all these guys in Northern Virginia who, on the advice of their attorney, pled guilty to something that gave them 365 days all suspended, and suddenly they're subject to being kicked out. Is that fair? My answer is no. I think this is really a bad thing. What would be your first instinct as to what an argument about what does that violate? Well, they're kicking him out because of it saying the 1997 statute gets him kicked out for his 1995 conduct. Yes, ex post facto. And generally there is a presumption against ex post facto application of laws, as you will find in every circuit court and the Supreme Court. However, Congress put in ERA, this is retroactive, we really mean it. Can Congress always do that? Can Congress just always make ex post facto laws? Right, because there's a constitutional provision. But guess what? The constitutional provision applies to criminal. And despite the fact that immigration violations involve you getting put in handcuffs and tossed in a jail cell and then kicked out of the country, the Supreme Court said that's not criminal. Sure feels like it's criminal, but it's not. And also, they said that that's how that that because of that, the executive branch and legislative branch have a lot of discretion because it's basically how will we treat foreigners is a matter of our own foreign policy, and thus the judicial branch is closed to intervene. Yes.
Was he able to change his
He had never been detained for the pushing.
But was he detained for victimization?
Yes, because they picked him up in like 2008. And they're like, hey, by the way, we discovered that back in 1995 we pushed this guy. And he took it out, even though he got away with kids and everything else. And then he wasn't being detained, and then all of a sudden he was. This was kind of like a happy surprise when they, oh yeah, he got picked up. So we had to do a habeas petition. But so that was really exciting. We actually brought we brought habeas petition, we brought it up to the Fourth Circuit. Fourth Circuit rejected it. Then the Supreme Court issued a decision while the time for reconsideration was still pending, so we filed a motion for reconsideration. I think everyone was like, maybe we don't want bad law about retroactivity in the Fourth Circuit, so they let our guys stay. So that's sort of the example of the good you can do and the fairness you can read. Well, thank you very much for your time. If you have any questions, you can find me online. Thanks so much.